I was standing in my driveway on a sunny Tuesday morning in Phoenix, Arizona, when I first realized my peaceful suburban life was about to become a bureaucratic nightmare involving a woman who would make my next 6 months feel like an eternity of paperwork and legal threats. The trencher sat exactly where I had parked it the night before, right next to my work truck in the extended driveway of my home at 4427 Desert Vista Lane. It was a ditch which SK 752, compact enough to fit in the space without blocking the sidewalk or extending into the street, yet apparently offensive enough to warrant the attention of someone with too much time on their hands. I had just finished a massive underground cable installation job for a new commercial complex on the east side of Phoenix, and honestly, I was exhausted. The last thing I expected was trouble over storing my equipment at my own house. My name is Keith Vance, and I have been working as a licensed underground cable installer in Arizona for the past 8 years. I run my own small business, Vance Underground Solutions, with 2 employees and a steady stream of contracts from telecommunications companies and construction firms throughout the Phoenix metropolitan area. The work is hard, the hours are long, but I make a decent living and I take pride in what I do. Every wire I bury, every conduit I run, connects people to the services they need. It matters. The trencher was my biggest investment aside from my house itself. $42,000 of specialized machinery that allowed me to take on larger jobs without having to rent equipment constantly. I had saved for 3 years to buy it outright, and it had already paid for itself twice over in the 18 months since I purchased it. Keeping it at my house between jobs made perfect sense. My HOA covenants said nothing about commercial vehicles or equipment, or at least I thought they did not. I had read through that thick packet of documents when I bought the house 4 years ago, and while there were rules about boat storage and RV parking, I saw nothing that would prohibit what I was doing. I was pouring my second cup of coffee when the doorbell rang. Through the frosted glass panel beside my front door, I could see a silhouette that screamed self-importance. I opened the door to find a woman in her late 40s with blonde hair styled in that specific way that somehow communicates both suburban sophistication and barely contained rage. She wore white capri pants, a pink polo shirt, and sunglasses perched on top of her head despite the Arizona sun already beating down at 8 in the morning. "Good morning," I said, trying to start things off friendly. "Can I help you?" "I certainly hope so," she said, her voice dripping with that particular tone that suggests she has already decided you are guilty of whatever crime she has invented. "I am Carol Richardson, president of the Desert Vista Homeowners Association Board, and you are Keith Vance, correct?" "That would be me," I said, still holding my coffee mug. "What can I do for you?" She gestured dramatically toward my driveway. "That monstrosity you have parked in your driveway is in direct violation of our community covenants. Section 12, subsection 4 clearly states that no commercial equipment may be stored in visible areas of the property." I blinked at her, processing this information. I read through the covenants when I bought the house. I do not remember seeing anything about that. Carol pulled out a folder from under her arm with the flourish of a prosecutor presenting damning evidence. "Well, perhaps you should have read more carefully. The board updated the covenants 2 years ago, and all homeowners were sent copies via certified mail. You signed for yours on March 15th, 2 years ago." I vaguely remembered getting some thick envelope from the HOA, but honestly, I had been in the middle of a huge project at the time and probably just filed it away without reading every single page. That was looking like a mistake now. "Okay," I said, trying to remain calm. Let us say you are right about the rule. I need to store my equipment somewhere. It is essential for my business. What would you suggest? That is not my problem, Carol said with a slight shake of her head. Rent a storage unit. Build a garage large enough to contain it. I do not care. But that thing needs to be removed from your driveway by the end of this week, or you will be fined $500. And the fine will continue at $500 per week until you come into compliance. $500 a week. I nearly choked on my coffee. That is insane. Look, can we at least discuss this? Maybe I can apply for a variance or something. The variance process takes a minimum of 60 days and requires a fee of $250 just to apply, Carol said, clearly enjoying this. And I can tell you right now that the board will not approve it. We have standards in this community. If we let you keep commercial equipment in your driveway, what is next? Someone running a mechanic shop, a landscaping business storing trailers and mowers everywhere. No, Mr. Vance. Rules exist for a reason. I felt my jaw tighten. This is how I make my living. That trencher is worth more than most people's cars. I cannot just leave it in some storage unit miles away. I need access to it. Again, not my problem, Carol said. She reached into her folder and pulled out an official-looking document. This is your formal notice of violation. You have until this Sunday at midnight to remove the equipment. The clock is ticking, Mr. Vance. I suggest you make arrangements. She turned on her heel and walked back to her white Lexus SUV parked at the curb. I stood there holding the notice, watching her drive away and feeling a familiar anger building in my chest. It was the same anger I felt whenever I encountered petty bureaucrats who wielded their tiny amount of power like tyrants. I had served in the Army for 4 years before getting into the cable installation business, and I had met more than my share of small-minded martinets who got off on making other people's lives difficult. I went back inside and actually read the notice. It was printed on fancy HOA letterhead and detailed my supposed violation in officious language that would make a lawyer proud. At the bottom was a note about my right to appeal to the full board at their next meeting, which was not for another 3 weeks. Of course, the fines would accumulate during that time, so even if I won the appeal, I would be out several $1,000s first. My phone rang. It was Marcus, one of my 2 employees, calling about our next job scheduled to start on Thursday. We had a contract to run underground cable for a new subdivision in Scottsdale, and I needed the trencher for that work. I explained the situation to him briefly. Man, that is messed up, Marcus said. What are you going to do? I am going to figure it out, I told him. In the meantime, let me call you back in an hour. I need to make some calls. I spent the next hour on the phone with various people. First, I called a lawyer friend of mine, Daniel Park, who did some real estate work. He listened to my story and pulled up the Desert Vista HOA covenants online. Yeah, they did update these, Daniel said. And there is language in here about commercial equipment. But here is the thing, Keith. The language is pretty vague. It talks about equipment that creates noise, pollution, or visual blight. A trencher just sitting in your driveway, not running, not doing anything, could potentially be argued as not violating the intent of the covenant. Could potentially be argued is not exactly a strong legal position, I said. No, it is not, Daniel admitted. But here is what I think you should do. First, document everything. Take pictures of how you have the trencher stored. Make sure you can show that it is not blocking anything, not creating any safety hazards, nothing like that. Second, check your municipal codes. Sometimes HOA covenants cannot override local ordinances. If Phoenix or your specific area has rules that protect home-based businesses, that might give you some leverage. What about the fine? Can they really charge me $500 a week? If it is in the covenants and you signed off on them, yeah, they can assess the fine. Whether they can actually collect it is another matter. They would have to take you to court, put a lien on your house, all of that. It is a process. But it is also a huge pain in the neck for you, and they know that. A lot of people just give in because fighting costs more than complying. I am not a lot of people, I said. Daniel laughed. I know you are not, man. Okay, do what I suggested. Document everything. And hey, check with the state licensing board. Arizona has pretty specific rules about licensed contractors and their equipment. There might be something there that helps you. That last suggestion stuck with me after we hung up. I held a valid Arizona Registrar of Contractors license as a specialty contractor for underground utilities. I also held several certifications from equipment manufacturers and had completed all the required training and insurance bonding that the state mandated. Surely there had to be some protection for licensed professionals trying to run legitimate businesses. I called the Arizona Registrar of Contractors office and eventually got through to a woman named Patricia who handled contractor inquiries. I explained my situation in detail. Okay, Mr. Vance, Patricia said after listening patiently. What you are describing touches on a few different areas of law. First, Arizona has what we call right-to-work provisions that protect licensed contractors from certain restrictions on running their businesses from residential locations, provided they are not creating nuisances. Second, your licensing as an underground utility contractor specifically requires you to maintain equipment in good working order and have it available for inspections if needed. If your HOA is preventing you from storing your licensed equipment, they could potentially be interfering with your ability to maintain your license. Really? I felt a spark of hope. Is that actually written down somewhere? Give me your email address, and I will send you the relevant statutes and administrative codes, Patricia said. You might also want to reach out to the Arizona Department of Real Estate. They handle some HOA oversight issues. But honestly, a lot of this might come down to how the specific language in your HOA covenants interacts with state law. You might need a lawyer who specializes in HOA disputes. Everyone keeps telling me I need a lawyer, I said. I was really hoping to avoid that expense. I understand, Patricia said sympathetically. But sometimes you have to spend a little to save a lot. One more thing, though. Document your license status, your insurance, everything that shows you are a legitimate, legal, properly licensed business operator. That stuff matters when you are making the case that you are not just some guy with a piece of heavy equipment, but a professional who needs his tools. I thanked her and hung up, then spent the next hour going through my files and pulling together everything that demonstrated my legitimate business status. My contractor license, my liability insurance policy, my commercial vehicle registration, my business license from the city of Phoenix, my tax returns showing my business income, training certificates from Ditch Witch and other equipment manufacturers, safety certifications, everything I could think of. By the time I finished, I had a folder almost as thick as the one Carol Richardson had been carrying. I took detailed photos of the trencher from every angle, showing how it was positioned, how much space it took up, and how it was secured and locked. I measured the distances from property lines and sidewalks. I documented that my driveway was actually larger than standard because the previous owner had extended it, and that the trencher fit entirely within my property boundaries with room to spare. Wednesday came and went. I kept the trencher where it was. I was not going to be bullied into spending thousands of dollars on storage or scrambling to find a solution in less than a week, because Carol Richardson decided to flex her HOA president muscles. I started the Scottsdale job on Thursday morning, which meant I needed the trencher anyway. We loaded it onto my trailer and headed out. The job went smoothly. We were running fiber optic cable for a telecommunications company, trenching neat lines through what would eventually be front yards, carefully avoiding the marked locations of existing utilities, following all the proper procedures. This was work I was good at, work I took pride in. The idea that Carol Richardson thought storing the equipment that made this work possible was somehow a blight on the neighborhood was absurd to me. Friday afternoon, I got home around 5 and backed the trencher back into its usual spot. There was a new notice on my door. This one informed me that I had now officially violated the covenant, that the fine structure was in effect, and that I owed $500. It included a payment slip and instructions for submitting payment to the HOA management company. I crumpled it up and threw it in the recycling bin. Saturday morning, I was in my garage organizing tools when Carol Richardson appeared again, this time with 2 other people. One was a man about my age, fit and serious looking. The other was an older woman with gray hair and an expression like she had just smelled something unpleasant. "Mr. Vance," Carol called out, "we need to speak with you." I put down the wrench I was holding and walked out to meet them. "What can I do for you, Carol? This is Frank Morrison, our HOA board treasurer, and Helen Sutherland, board secretary," Carol said, gesturing to her companions. "We are here to discuss your continued violation of community covenants." "I got your notice," I said. "I do not agree with it." Frank stepped forward. He had the air of someone who thought being on an HOA board gave him real authority. "Whether you agree with it or not is irrelevant. The covenants are clear. Commercial equipment cannot be stored in visible areas. You are in violation. The fine stands." "The covenants are not as clear as you think they are," I said, "and I have done some research. Arizona law protects licensed contractors from exactly this kind of harassment." "Harassment?" Helen spoke up for the first time, her voice shrill. "We are enforcing rules that you agreed to when you purchased your home. That is not harassment. That is responsible community governance. You want to talk about responsible governance?" I was starting to lose my patience. "How about you tell me what actual harm my trencher is causing? Is it making noise? No. Is it leaking fluids? No. Is it blocking anything? No. Is it even ugly? It is a piece of modern equipment, well maintained, sitting quietly in my driveway." Meanwhile, Jim Henshaw, 3 houses down, has had a broken-down boat in his side yard for 2 years, but I do not see you hassling him. "The boat is behind a fence," Carol said quickly. "Your trencher is visible from the street." "So this is about visibility," I said. "About appearances. About you not liking the fact that someone in your precious neighborhood actually works for a living with his hands." Carol's face flushed. "Do not you dare try to make this about class or elitism. This is about maintaining property values. This is about all of us following the same rules so that our community remains desirable. If you want to operate a business with commercial equipment, you should have bought property in a commercial or industrial zone." "I live here," I said, pointing at my house. "This is my home. I am not running a business out of my garage with customers coming and going at all hours. I am not creating any disturbance. I am simply storing the equipment I need for my work, equipment that I am legally licensed to own and operate, equipment that Arizona law says I have a right to maintain." "Show me the law," Frank challenged. "Show me something that says we cannot enforce our covenants." I went inside and came back with the printouts Patricia had sent me from the Arizona Registrar of Contractors' office. "Arizona Revised Statutes, Title 32, Chapter 10, I said, handing them the papers. specifically covers contractor licensing and includes provisions about equipment storage and maintenance requirements. There is also administrative code about interference with licensed contractor operations. They passed the papers around, skimming them. Carol handed them back to me with a dismissive wave. This does not say what you think it says. These are general provisions. They do not override specific covenant agreements. You are grasping at straws, Mr. Vance. Fine, I said. Then let us go to court and let a judge decide. Because I am not paying your fine and I am not moving my trencher. Helen gasped like I had just committed a mortal sin. You are going to force us to take legal action against you. You are the ones issuing threats and fines, I said. I am just trying to live my life and do my job. If you want to escalate this to lawyers and courts, that is your choice. But I promise you, I am not going to roll over just because you wave some covenant papers at me. We stood there in tense silence for a moment. Finally, Carol spoke again, her voice cold. Fine. You want to do this the hard way, we will do it the hard way. Expect a formal notice of intent to file a lien on your property, and the fines will continue to accumulate, $500 per week. By the time this is done, you could owe us thousands. Or, I said evenly, by the time this is done, I could own all of you for harassment and interference with a licensed business operation. Works both ways, Carol. They left, and I immediately called Daniel Park again. This was clearly heading for legal action, and I needed someone in my corner who actually understood the law. Daniel agreed to take the case, and said he would start by sending a formal letter to the HOA demanding they cease their enforcement action and threatening a counter-suit if they did not. This is going to get expensive, Daniel warned me. Are you sure you want to fight this? It might be cheaper to just rent a storage unit. It is not about the money anymore, I said. It is about the principle. They do not get to push people around just because they are on some board. The following week was quiet on the HOA front, but I knew it was just the calm before the storm. Daniel sent his letter on Monday. By Friday, we had a response from the HOA's lawyer, a firm out of Temp that specialized in HOA representation. The letter was full of legalese, but the basic message was clear. The HOA believed it was within its rights, the covenants were valid and enforceable, and they intended to pursue all available remedies including fines and liens. Okay, Daniel said when we met to discuss it. Here is where we are. They are definitely going to file a lien if you do not pay the fines. That does not mean they can force you to pay or take your house immediately, but it is a cloud on your title. You would not be able to sell or refinance until it is resolved. They are also going to file in court for an injunction to force you to remove the trencher. What are our chances? I asked. Daniel leaned back in his chair. Honestly, it is hard to say. Arizona courts generally uphold HOA covenants as long as they are not unconscionable or in direct conflict with state law. What we need to do is build a strong case that their enforcement is either selective, arbitrary, or conflicts with your rights as a licensed contractor. The contractor licensing angle is our best bet, but it is not a slam dunk. What would make it stronger? I asked. Testimony or documentation showing that the HOA has allowed similar situations for other homeowners, Daniel said. Proof that this is targeting you specifically. Also, expert testimony about what you need as a licensed contractor and why their restrictions interfere with your ability to operate legally. Think of anyone who might support our position. Other contractors in the neighborhood. Anyone on the HOA board who might be sympathetic. I thought about it. There was one guy I knew casually, Tom Brennan, who lived 2 streets over. He ran a plumbing business and definitely had commercial vehicles at his house. I had seen his trucks there multiple times. I made a mental note to talk to him. That weekend, I went for a walk through the neighborhood, really paying attention to what other people had in their driveways and yards. Tom's house had 2 plumbing trucks parked outside. Another house had a large work van for what looked like an electrical contractor. Someone else had a landscaping trailer. There was even a house with what appeared to be a small excavator on a trailer in the driveway, though it was partially covered with a tarp. I took photos of everything, being careful not to be obvious about it. If the HOA was going to claim they were enforcing rules evenly, I wanted evidence to the contrary. Monday morning, I knocked on Tom Brennan's door. He answered in work clothes, clearly about to head out for a job. "Hey, Keith," Tom said. "What brings you by?" I explained the situation with the HOA. Tom listened, his expression growing more concerned. "That is ridiculous," Tom said when I finished. "I've had my trucks here for 3 years and never heard a word from the HOA. But then again, I am not on Carol Richardson's radar." "You must have pissed her off somehow." "Just by existing, apparently," I said. "Look, if this goes to court, would you be willing to testify that you keep commercial vehicles here without any problems? It would help show that they are enforcing this selectively." Tom hesitated. "Man, I do not want to get on the HOA's bad side. But yeah, that is not right what they are doing to you. If you need me to testify, I will do it. Just give me enough notice." "Thanks," I said. "I really appreciate it." Over the next few days, I documented everything I could find. I also reached out to other contractors I knew in the Phoenix area and asked about their experiences with HOAs. The stories I heard were eye-opening. One guy had been forced to sell his house and move because his HOA would not let him keep any work vehicles at home. Another had spent over $20,000 in legal fees fighting a similar battle and eventually gave up. But I also heard from a few who had won their cases, usually by proving that the HOA was being discriminatory or that their actions violated state licensing requirements. The court date for the injunction hearing was set for mid-November, about 6 weeks away. In the meantime, the HOA continued to assess weekly fines. By my count, they claimed I now owed $3,000. I did not pay any of it. Daniel advised me that paying would be seen as acknowledging the debt, which could hurt us later. Work continued. I had jobs lined up through the end of the year, and the trencher was essential for almost all of them. Every morning, I would load it up and head out. Every evening, I would bring it home and park it in the same spot. It became a routine and also a statement. I was not backing down. In early November, something unexpected happened. I got a call from a reporter at the Arizona Republic, Phoenix's major newspaper. Her name was Jennifer Walsh, and she was working on a story about HOA disputes in the state. "I heard about your case from a source at the courthouse," Jennifer said. "It sounds like an interesting example of the tensions between HOA rules and homeowner rights. Would you be willing to talk to me?" I talked to Daniel first. He thought media attention could work in our favor. If we can make this a public issue, it puts pressure on the HOA. They do not want to look like petty tyrants in the newspaper. So I agreed to the interview. Jennifer came to my house on a Wednesday afternoon and we talked for over an hour. I showed her the trencher, explained my business, walked her through the timeline of the dispute. She took notes and photos and seemed genuinely interested in the story. "This is exactly the kind of thing people need to hear about," Jennifer said. "HOAs have enormous power in Arizona. We have more HOA-governed communities than almost any other state, and the oversight is minimal. They can fine you lien your property, even foreclose in some cases. A lot of people do not realize what they are getting into when they buy in an HOA community." The article came out the following Sunday on the front page of the local section. The headline read, Phoenix contractor battles HOA over right to keep work equipment at home. It was a fair piece, presenting both sides but definitely making the HOA look petty and vindictive. The article mentioned Carol Richardson by name as the HOA president and included some quotes from the HOA's lawyer defending their actions. The response was immediate. My phone started ringing with calls from other contractors who had dealt with similar issues. I got emails from people in other HOA communities expressing support. Someone even started a Facebook group called Arizona Homeowners Against HOA Overreach, and my case became a rallying point. But the publicity also made the HOA dig in harder. Carol Richardson gave an interview to a local TV station, doubling down on their position. "Rules are rules," she said on camera, standing in front of the Desert Vista community sign. "If we make an exception for Mr. Vance, we will have to make exceptions for everyone. Our community has standards and we intend to maintain them." The TV station also interviewed me, of course. They came out and filmed the trencher, talked to my neighbors, got the full story. Most of my immediate neighbors supported me, or at least did not see any problem with what I was doing. One woman, Linda Carter, who lived directly across the street, went on camera saying, "I barely even noticed the trencher. Keith is a good neighbor, he keeps his property nice and he works hard. This whole thing is silly." By the time the court date arrived, the case had taken on a life of its own. There were actually a few people from the Facebook group in the courthouse hallway when I arrived with Daniel. They held signs saying things like "Support small business" and "HOA tyranny must end." I appreciated the support, though I was not sure how the judge would feel about it. The hearing was before Judge Michael Preston, a stern-looking man in his 60s who had a reputation for being no-nonsense. The HOA was represented by their lawyer, Arthur Steinberg, a slick corporate type who probably charged $400 an hour. Steinberg went first, presenting the HOA's case. He argued that the covenants were clear, that they had been properly updated and distributed to all homeowners, and that I was in flagrant violation. He showed photos of the trencher and claimed it was an eyesore that diminished property values. He cited case law supporting the enforceability of HOA covenants in Arizona. Then it was Daniel's turn. He presented our argument that the covenant language was vague and subject to interpretation, that I was a properly licensed contractor with a legal right to maintain my equipment, and that the HOA was enforcing its rules selectively. He showed the photos I had taken of other commercial vehicles and equipment in the neighborhood. "Your Honor," Daniel said, "the evidence clearly shows that Desert Vista HOA has allowed numerous other homeowners to keep commercial vehicles and equipment at their homes without any enforcement action. Mr. Vance is being singled out, and we believe this constitutes discriminatory enforcement. Furthermore, Arizona law protects licensed contractors in their ability to operate their businesses. The equipment in question is necessary for Mr. Vance to fulfill his legal obligations as a licensed contractor. The HOA's actions interfere with those obligations." We had also prepared declarations from Tom Brennan and 2 other contractors in the neighborhood, all stating that they kept commercial vehicles and equipment at their homes without HOA complaints. The judge read through everything carefully. "Mr. Steinberg," Judge Preston said, "how do you respond to the evidence of selective enforcement? I am looking at photos of what appears to be commercial vehicles and equipment at other properties in the same HOA community." Steinberg stood up. "Your Honor, the HOA is prepared to enforce its covenants against any and all violations. The fact that they may not have taken action against other properties yet does not mean they cannot enforce against this one. Furthermore, Mr. Vance's trencher is substantially larger and more industrial-looking than a typical work truck. But it is just sitting there, the judge said. Is there any evidence that it creates noise, pollution, safety hazards, anything like that? No, Your Honor, but the covenant does not require such evidence. It simply prohibits commercial equipment in visible areas. Judge Preston looked at our side. Mr. Park, you are arguing that your client's licensing status overrides the HOA covenant. Can you cite specific statutory language that supports this? Daniel stood and pulled out the relevant documents. Your Honor, Arizona Revised Statutes Title 32, Chapter 10, Section 1122. Subsection C specifically states that licensed contractors must maintain equipment in good working order and have it available for inspection by the registrar. Additionally, Arizona has right-to-work provisions that protect home-based businesses from unreasonable restrictions. While we acknowledge that HOA covenants are generally enforceable, they cannot be enforced in a way that prevents a homeowner from exercising their legal right to earn a living. The judge reviewed the statutes. The courtroom was quiet except for the rustling of papers. Here is what I am going to do, Judge Preston finally said. I am going to deny the HOA's request for an immediate injunction. However, I am going to schedule a full hearing on this matter for January. In the meantime, Mr. Vance may continue to keep his trencher at his property. The HOA will cease assessing fines until the matter is fully resolved. Both parties should be prepared to present complete evidence and arguments at the full hearing, including expert testimony if necessary about the licensing requirements and whether the HOA's actions constitute prohibited interference. It was not a complete victory, but it was something. The immediate pressure was off, and at least I was not going to be accumulating thousands of dollars in fines while we fought this out. Outside the courthouse, Jennifer Walsh interviewed me for a follow-up story. How do you feel about the judge's decision? She asked. Relieved, I said honestly. I just want to be able to do my job and live in my house without being harassed. I am hopeful that when the judge hears all the evidence, he will see that what I am doing is reasonable and legal. Carol Richardson walked past with Steinberg and the other board members. She glared at me but did not say anything. I could tell she was furious about the judge's decision. Over the next few weeks, things quieted down again. I continued working. The trencher stayed in my driveway, and the HOA left me alone for the time being. But I knew it was not over. They were preparing for the full hearing, and I needed to do the same. Daniel brought in an expert witness, a professor from Arizona State University who specialized in property law and HOA issues. Her name was Dr. Rachel Morrison, and after reviewing all the documents and evidence, she agreed to testify on my behalf. She told us that, in her professional opinion, the HOA's enforcement was clearly selective and discriminatory, and that their actions likely did violate my rights as a licensed contractor. We also got a declaration from an official at the Arizona Registrar of Contractors' office, confirming that licensed contractors are required to maintain their equipment, and that inability to store such equipment could impact license status. The holidays came and went. I spent Christmas with my family, trying not to think too much about the upcoming hearing. But it was always there in the back of my mind. This fight had taken over my life in ways I never expected. It was not just about the trencher anymore. It was about standing up to bullies who thought they could push people around because they had a little bit of authority. January arrived, and with it came the full hearing date. This time, the courtroom was more crowded. Members of the Arizona Homeowners Against HOA Overreach group showed up in force. There were also other contractors there to show support, and even a few reporters. The hearing lasted most of the day. Steinberg presented the HOA's full case, complete with testimony from Carol Richardson about the importance of maintaining community standards and property values. He brought in an appraiser who testified that commercial equipment in driveways could potentially lower nearby property values, though on cross-examination he admitted he had no specific data about my property or neighborhood. Carol herself took the stand. Daniel cross-examined her, and it did not go well for her. "Mr. Richardson," Daniel said, "you are aware that there are other homeowners in Desert Vista who keep commercial vehicles and equipment at their homes, correct?" "I have seen some work trucks, yes," Carol admitted reluctantly. "And has the HOA issued violations and fines to those homeowners?" "Not yet, but we plan to address those situations as well." "But you have not done so yet, correct? In fact, some of those situations have existed for years, and the HOA has never said a word until now. Is that correct?" Carol's face reddened. "We are addressing violations as we become aware of them." "Is it not true, Mr. Richardson, that you personally dislike Mr. Vance because of a dispute about parking during a neighborhood party last summer?" Steinberg objected, but the judge allowed the question. Carol sputtered. "That has nothing to do with this. This is about enforcing rules." "Please answer the question," Judge Preston said. "Did you have a personal dispute with Mr. Vance prior to this covenant enforcement action?" "We had a disagreement about parking," Carol admitted. "But that does not mean I am targeting him unfairly. His trencher is a genuine violation." Daniel introduced evidence of the parking dispute, which I had nearly forgotten about. It was at the neighborhood 4th of July party, and Carol had gotten upset because my truck was parked in a way that partially blocked her preferred spot. We had exchanged some heated words, but I thought it had blown over. Apparently not. When it was our turn, I took the stand and explained my situation in detail. I talked about my business, my licensing, the equipment requirements, and why the HOA's actions were making it difficult for me to operate legally. I was honest and straightforward, and I could see the judge paying close attention. Dr. Morrison testified as our expert, explaining the legal principles at stake and opining that the HOA's selective enforcement violated basic fairness and likely conflicted with state protections for licensed contractors. Tom Brennan and the other contractors testified about their own experiences keeping commercial vehicles and equipment at their homes without HOA complaints. By the end of the day, I felt good about our case. We had presented a strong argument backed up by solid evidence and expert testimony. The HOA's case, by contrast, had seemed petty and vindictive, especially after Carol's testimony revealed the personal animosity. Judge Preston took the matter under advisement and said he would issue a written ruling within 30 days. Those 30 days were nerve-wracking. I tried to focus on work, but it was hard not to constantly wonder what the judge was thinking and which way he would rule. Daniel kept telling me he felt optimistic, but nothing was certain. Finally, in early February, the ruling came. Daniel called me as soon as he got the notice. "We won," he said, and I could hear the excitement in his voice. "The judge ruled in your favor on every point." I felt a wave of relief so powerful I actually had to sit down. "Tell me everything." "Okay." So the judge found that the HOA covenant language about commercial equipment is impermissibly vague, and that the HOA has enforced it in an arbitrary and discriminatory manner. He specifically cited the evidence we presented showing other commercial vehicles and equipment in the neighborhood. He also found that, as a licensed contractor, you have a legitimate need to store your equipment, and that the HOA's actions interfered with your ability to maintain your license and operate your business. He issued an injunction prohibiting the HOA from enforcing that provision of the covenant against you. He also voided all the fines they had assessed and ordered them to pay your attorney's fees. "They have to pay our legal fees," I said. "How much is that?" "About $12,000 so far," Daniel said. "But here is the best part. The judge also ordered the HOA to revise their covenant language to be more specific and to apply it consistently to all homeowners. And he retained jurisdiction, which means if they try to retaliate against you in some other way, we can go right back to him." I could have cried. After months of stress and fighting and worrying, it was finally over. I had won. The news spread quickly. Jennifer Walsh wrote another article. This one headlined "Contractor Defeats HOA in Equipment Storage Dispute." The Arizona Homeowners Against HOA Overreach group celebrated it as a major victory. Other contractors reached out to thank me for standing up and fighting. But the real satisfaction came a few days later when I got a certified letter from the Desert Vista HOA. It was signed by Frank Morrison, not Carol Richardson, and it formally notified me that the HOA was withdrawing all enforcement actions against me and that the fines were voided. It was a very different tone from the imperious notices Carol had delivered. I later found out through neighborhood gossip that Carol had resigned from the HOA board shortly after the ruling. Apparently, several homeowners had filed complaints about her conduct during the dispute, and the other board members had basically forced her out. Frank Morrison was now the president, and from what I heard, he was taking a much more reasonable approach to HOA governance. A few weeks after the ruling, Frank actually came by my house. I was working on my truck in the garage when he walked up. "Keith," he said, extending his hand. "I wanted to apologize for how this whole thing went down. Carol let personal feelings cloud her judgment, and the board should have reined her in earlier. The truth is, your trencher is not a problem. It never was. We were wrong to come after you like that." I shook his hand. "I appreciate you saying that, Frank. I never wanted a fight. I just wanted to be left alone to do my work and live my life." "I get that now," Frank said. "We are working on revising the covenants like the judge ordered. We want to make them clear and fair, and we want to enforce them consistently. No more targeting people because of personal grudges." "That sounds like a good plan," I said. As the months passed, life returned to normal. The trencher stayed in my driveway. I kept running my business, taking on new contracts, making a living. The attention from the court case actually brought me some new clients who had seen the news coverage and liked the idea of supporting someone who stood up for small business rights. I never saw Carol Richardson again. I heard she moved to a different neighborhood, which was probably for the best. Some people just should not be in positions of power, even small, petty positions like HOA board president. The whole experience taught me a lot about standing up for yourself and not backing down when you know you are right. It also taught me about the importance of documentation, expert help, and sometimes just being willing to fight. A lot of people would have given in, paid the fines, moved the trencher, whatever it took to avoid conflict. But that would have meant letting bullies win, and I was not willing to do that. Looking back now, from the perspective of a couple of years, I am glad it happened the way it did. Not because it was fun or easy, but because it made me stronger and more confident in dealing with authority figures who overstep. It also made my neighborhood better. The new HOA board under Frank's leadership is more reasonable and transparent. They still enforce rules when necessary, but they do it fairly and consistently, without personal vendettas driving their decisions. The trencher still sits in my driveway when I am not using it. Every time I look at it, I am reminded of the battle I fought and won. It is just a piece of equipment, but it represents something bigger. The right to live your life, run your business, and be left in peace as long as you are not hurting anyone. My business has grown since then. I hired a third employee and bought a second trencher. Sometimes I park both of them in my driveway, and nobody says a word. The neighbors are used to seeing my work trucks and equipment coming and going. It is just part of the neighborhood now, accepted and unremarkable. I still see Tom Brennan around, and he still has his plumbing trucks parked at his house. The guy with the excavator on the trailer is still there too. The HOA never went after any of them, which tells me that the whole thing with me really was personal on Carol's part. She picked the wrong target. Daniel Park and I stayed friends. He handled some other work for me over the years, and I have referred other contractors to him when they run into HOA problems. He told me that my case actually became cited in a few other HOA disputes around Arizona as precedent for protecting contractor rights. That made me proud. The whole ordeal probably cost me $20,000 when you factor in legal fees, time spent fighting instead of working, and general stress and hassle. But getting $12,000 back in attorney's fees helped, and more importantly, I established the principle that HOA boards cannot just do whatever they want. There are limits. There are rights that homeowners have. And sometimes you have to stand up and fight for those rights. Would I do it again? Absolutely. Would I recommend that others in similar situations fight back? That is a harder question. Every situation is different. You need to weigh the costs, both financial and emotional. You need to have documentation and evidence. You need to be prepared for months of stress and conflict. But if you are in the right, and you have the resources and support to fight, then yes, sometimes you have to take a stand. These days, when I drive through my neighborhood, I see it differently than I did before. I see the houses, the lawns, the driveways, but I also see the invisible web of rules and covenants that govern everything. Most people never think about their HOA until there is a problem. They pay their dues, follow the obvious rules about lawn care and holiday decorations, and assume everything is fine. But there is a whole apparatus of governance that can be turned against you if someone decides they do not like you, or if you happen to violate some obscure covenant provision. That is not meant to scare people away from HOA communities. Most HOAs are fine, run by reasonable people who just want to keep the neighborhood pleasant. But you need to know what you are getting into. Read those covenants carefully. Understand what rights you are giving up. Pay attention to who serves on the board and how they operate. And if you ever find yourself in a dispute, document everything and do not be afraid to stand up for yourself. My trencher is more than just a tool now. It is a symbol of a fight won, of rights preserved, of refusing to be bullied. Every time I fire it up for a new job, cutting clean lines through the earth to lay the cables that connect our modern world, I think about the battle it took just to keep it parked at my own house. It seems absurd in retrospect, but that is the nature of HOA disputes. Small things become huge because of personality conflicts and petty power plays. I am glad I fought. I am glad I won. And I hope my story encourages others who face similar situations to stand their ground. We all deserve to live in our homes, work in our trades, and pursue our livelihoods without harassment from small-minded bureaucrats who mistake their limited authority for actual power. The law, imperfect as it sometimes is, still offers protections. Judges, when presented with clear evidence and strong arguments, can still recognize injustice and rule fairly. In the end, that is what happened in my case. A judge looked at the evidence, saw through the HOA's pretexts, recognized the personal animosity and selective enforcement, and ruled in favor of common sense and fairness. The system worked, but only because I was willing to engage with it, to fight through it, to spend the time and money and emotional energy necessary to see it through to the end. My advice to anyone facing a similar situation is simple. Know your rights, document everything, get expert help, and do not give in just because fighting is hard. Some battles are worth fighting, not just for yourself but for everyone who comes after you. My victory made it a little bit easier for the next contractor who faces an unreasonable HOA. It established a precedent, set an example, showed that ordinary people can push back against petty tyranny and win. The trencher will probably stay in my driveway for years to come, a $42,000 reminder that sometimes you have to stand and fight for what is yours. It is not the most dramatic story, not the most exciting battle, but it mattered to me. It still matters. And every time Carol Richardson, wherever she is now, thinks about it, I hope she remembers the lesson. You cannot push everyone around. Some people push back. And sometimes, justice actually prevails.